Thank you, Deputy Callan. Thank you, Cahirlock. And I too want to welcome the O'Farrell family to the Chamber and sympathise with them in the loss of their son. I had the pleasure of meeting Mrs. O'Farrell recently in Leinster House 2000, and we had a conversation about the case, all too brief unfortunately, but I am mindful of it, and I want to also recognise the work of my colleague Deputy John McGuinness in continuing to highlight this over several years. And I remember well that debate in 2018-2019, as has been referenced already, when these houses voted, I think both houses actually voted to perform a public inquiry on this matter. The first thing I want to say is I'm at a loss actually to understand why we are the arm of the state tasked with decisions of the people. We are the Parliamentary Assembly, we're the Oireachtas. So if we've made a decision in both houses, why is that second guessed by a scoping inquiry? Why does that go off to somewhere else to be see it happen? When I was on the County Council, it was a great frustration to many members that a motion on a minor matter would be second guessed and overruled by an official, a civil servant at some stage, to say, well, you can't have that streetlight there, or that road repair there because an engineer deems otherwise, even though it might have been voted through by the Chamber. That was a very local, micro level. Perhaps understandable, although dubious from a democratic perspective. But this is a really major, important report about how we manage the criminal justice system, voted through by two houses of the Oireachtas. Why does it go off to another report to be scoped and then come back and say, no, you don't need a public inquiry when these chambers that are elected to decide these things have voted for it? I really, really struggle to understand that. That's the first point. I think there's a democratic deficit in that point. I suppose, turning to the detail of what's happened here, there seems to be a catalogue of errors, both in the reports and both on what happened and how the individual was allowed to remain in bail. It's a continuous frustration of the general public, and I think many of us in these houses, that people can become repeat offenders and continue while on bail to commit other crimes. And that revolving door system is often criticised, often rightly. Occasionally there can be good reason for it, but with 42 or 44 offences, it seems extraordinary that a person was allowed to go on. There are legitimate questions that have been asked by people in this chamber and by the family and others. Was he a confidential informant? Were there other reasons? Was discretion correctly applied in terms of drugs charges? I think that the family deserve to know the answers to those questions and how those traversed in a public, open forum, if necessary in an adversarial nature, where there can be cross-examined and examined for both sides, and people have a right of audience and a right to say and a right of rebuttal. But that's how we get to the truth. That's the engine for the truth, is cross-examination. That's what a public inquiry would do. On the administrative piece, I understand that there was at least probably a catalogue of administrative errors, but one of the more serious errors was that I think a court report or court order was incorrectly filed or was mislaid, or certainly didn't carry the ramifications that it should have done in terms of another offence and how that carried across and how that was implemented or otherwise. And one could ask, how can that happen? But I actually have a fairly good idea how it happened, not necessarily in this particular case, but from seeing many cases across both local, district and circuit courts across a number of years. The registrars and the system are just overworked and overwhelmed. And on the Justice Committee, which I obviously chair, and many of my colleagues are present in the Chamber now for the Justice Committee, we have repeatedly said that the judicial resourcing must be increased, not just about the judges, which is sometimes a misnomer, but about the court system. That includes registrars, support staff, people that are there to move the orders, the administrative backup, to ensure that these kind of errors don't get made, because they have really serious ramifications. This error could have resulted in an unnecessary and unavoidable death. That's about as serious as it can get. So that's an argument for investment in judicial resources. The Minister is and the State are doing that now, but it's taken a while to get there. But it's been a consistent theme of the Justice Committee that we need investment in the court system, in judicial resources and all the support services, and perhaps we'll avoid this happening again, which I think must be the foremost goal of all that speak on this. Thank you.